You know, if you've ever lived in a neighborhood with a homeowners association, you know the rules can be a source of, well, let's call it passionate discussion. From the color of your front door to, yep, where you can park your car. Today, we're going to dive into a real-life legal battle that all started with a simple change to a neighborhood's parking policy.
It's the question on every homeowner's mind when they get that little notice taped to their door, right? Can you actually take on the board and come out on top? Well, we are about to follow the story of one homeowner who did exactly that. She took her HOA all the way to a hearing, so let's see how it all played out.
All right, so here's our roadmap. We'll kick things off with the dispute itself, then we'll look at the case from the homeowner side, and then the HOA side. After that, we get to the judge's final ruling, and this is the important part. We'll break down why the homeowner lost, and finally, we'll talk about what this means for you. So let's set the scene. We're in the Vincenz Homeowners Association, and back in 2020, the board did something pretty unusual. They actually made a rule less strict. They passed a new policy on parking, and that single decision ended up picking off a huge legal fight. Okay, so let's meet the players in this showdown. First up, we've got Laura Ganer. She's the homeowner, the one filing the complaint. In the other corner, you have the Vincenz HOA, defending its new rule. And the referee in all this? The Office of Administrative Hearings, which had to make the final call.
And this right here, this is the policy that started the whole firestorm. The board officially resolved to allow on-street parking in front of homes and in common areas. So instead of cracking down, they were actually loosening the reins. But for one homeowner, this newfound freedom was a huge problem.
And that brings us to Ms. Garner's side of the story. She was convinced that the HOA board had no right to make this kind of change. So she filed a formal petition, basically accusing the HOA of breaking its own foundational rules.
Her whole case really boiled down to one core idea, that this new rule was just plain unreasonable. She felt like it just opened the floodgates, turning the entire neighborhood into a free-for-all for parking, which she believed went completely against the community's original design.
Now, to back this up, she pointed straight to the community's rulebook, the CC&Rs, and you got to look closely at this wording. Ms. Ganer's interpretation was that this rule was meant to be super restrictive, like parking is only for garages and driveways. That last little phrase, she argued, was just for a few minor exceptions, not for designating the whole neighborhood as a parking lot.
And then she hit them with this. This was her ace in the hole. The rules explicitly state that all association rules shall be reasonable. Her argument was that a policy that allows parking virtually everywhere just isn't reasonable, so therefore it's an invalid rule. Seems like a pretty good argument, doesn't it?
But hold on. Let's flip over to the HOA's defense. What's so interesting here is that the HOA didn't really bring in any new evidence. Nope. They took the exact same rules Ms. Ganer was using and said, see, this proves we were totally within our rights.
And this chart just lays out the clash perfectly. She says unreasonable, they say valid exercise of authority. She says the rules are meant to restrict parking, they say the rules explicitly let them designate parking. And here's the kicker. The HOA argued that she never actually pointed to a single car parked illegally. She just said she didn't like the new policy.
The HOA's entire defense really hung on this one little phrase right here. They argued this wasn't some tiny exception. To them, this was a clear, unambiguous grant of power. They said the community's own documents gave the board the authority to designate new parking areas. And that's exactly what they did.
So you've got two sides looking at the exact same words and coming to completely opposite conclusions. This is where the law steps in. The whole thing went before an administrative law judge who had to sort through it all and make a final, binding decision.
Now, before we get to the verdict, you have to understand this legal term. It's really important. In a case like this, the homeowner, Ms. Ganer, had the burden of proof. She had to prove her claim by a preponderance of the evidence. That just means she had to convince the judge that her side of the story was more probably true than not. The scales had to tip, even just slightly, in her favor.
So the judge's thought process basically went like this. First, did Ms. Ganer actually prove that a rule was broken? Second, when you read all the CC&Rs together, what do they really mean? And third, this is a huge principle in law. If the language in a contract is clear, if it's unambiguous, you have to enforce it exactly as it's written. No ifs, ands, or buts.
And with that, the hammer came down. The judge sided with the Homeowners Association. Ms. Ganer's petition was dismissed. She lost the case.
Okay, but just knowing who won isn't the point. The most critical part of this whole story is understanding why she lost.
because the judge's reasoning is a masterclass for anyone who lives in an HOA community.
So here's how it all broke down. The judge basically said that Ms. Ganer's feelings about the rule being unreasonable just weren't legal proof of anything. The language in the CC&Rs was crystal clear. It gave the board the power to designate parking areas. Since she couldn't point to a specific existing rule that the board had actually broken, her whole argument just fell apart.
And if there is one sentence to take away from this entire case, it's this one. Disagreeing with a decision the board made is one thing, but that's not the same, legally speaking, as proving they violated a rule that was already on the books. There's a huge difference between not liking a policy and that policy being illegal. All right, so what does this little neighborhood drama in Arizona mean for the rest of us? Well, it actually gives us a really clear playbook on what it takes to successfully challenge your HOA and what doesn't work.
The lesson here is so clear. If you want to fight your HOA and have a real shot at winning, your opinion that a rule is unfair or unreasonable just isn't gonna cut it. You have to be able to open up that big book of rules, point to a specific article, a specific section, and prove that the board violated that. You need a legal argument, not just an emotional one.
Which kind of leaves us with one last question to chew on. We all think we know the rules of our neighborhood, right? But this case shows that the specific wording, that one little clause you skimmed over, can change absolutely everything. So, the real question is, have you actually read your CC&Rs, cover to cover? Do you really know what powers you've given your board?